Hello everyone. We hope that you are doing well. If this is your first time on this channel, welcome to YouTube official verified U.S. Immigration Updates channel, and welcome back if you are returning. We have got some significant news to discuss that could have far-reaching implications on immigration policies and the border. In this video, we're going to talk about the big initiative taken by more than 100 House Democrats who recommending and urging President Joe Biden to use all the tools available to help immigrants. So once again, good morning, afternoon, or evening, ladies and gentlemen, wherever you are, and welcome again. If you are interested in learning more about this topic, stay tuned until the end of this video. If you like this video, please click the subscribe button, the like this video button. And don't forget to press the bell icon to get new updates instantly and directly to your YouTube. So, without any further delay, now let's get into the video and find out what the latest updates are on U.S. immigration. As House Republicans demand more border security measures from their perch in the majority, where Democrats are asking President Joe Biden to use his executive status to further their party's immigration goals. Reps. Jerry Nadler and Pramila Jayapal, ranking members of the House Judiciary Committee and Immigration Subcommittee, respectively, led a letter from 103 Democrats to Biden and Homeland Security Secretary Alejandro Mayorkas. It asked that officials use all the tools available to provide stability to undocumented individuals and recently arrived asylum seekers, seeking to work lawfully, support their families, and contribute to the economy. Now's look at the letter that has written by Democrats and recommendation for immigration reform. Dear President Biden and Secretary Mayorkas, we write to urge the administration to use all the tools available to provide stability to undocumented individuals and recently arrived asylum seekers, seeking to work lawfully, support their families, and contribute to the economy. While this letter does not focus on temporary protected status, TPS, many of these individuals come from countries that warrant a designation or redesignation of TPS, and we support those ongoing efforts. Detailed below are a variety of additional authorities and actions the administration can take to assist certain undocumented individuals who are stuck in limbo and asylum seekers in obtaining work authorization while they wait for their immigration court case to be heard. Asylum regulation and parole. The administration should ease the undue delays in granting work authorizations to asylum seekers. Due to significant immigration court backlogs, many asylum seekers cannot apply for asylum for a substantial period of time. As a result, through no fault of their own, they remain ineligible to work, making them unable to provide for their families and contribute to the economy. Many asylum seekers want to work and give back to their new communities. Likewise, many states, cities, and communities have enthusiastically welcomed these asylum seekers. The administration could assist asylum seekers and their communities by increasing the use of parole and decreasing the regulatory 150-day wait period for asylum seekers to apply for work authorization. Asylum seekers should be permitted to apply to obtain work authorization from the moment that they file their asylum claim. Of the Immigration and Nationality Act, INA, requires that asylum applicants may not be granted work authorization until their asylum application has been pending for a minimum of 180 days. As a result, asylum seekers are forced to rely on underfunded community groups to provide them with everything from housing to food to health services. This is particularly troubling given the tight labor market we are experiencing across the country. Millions of new arrivals deserve dignified labor and a chance at rebuilding their lives, and allowing them to swiftly enter the formal workforce will bolster economic growth and support struggling industries. Allowing earlier access to work permits would decrease the pressure on states, cities, localities, and other community groups and provide asylum seekers with the opportunity to live more independent lives, find legal representation, and increase economic growth. At the same time, the administration should consider, on a case-by-case basis, humanitarian parole for migrants who entered the United States during the use of Title 42. which includes individuals who entered between March 2020 to May 2023. The parole authority under the INA allows individuals to enter the United States for a period of time for urgent humanitarian reasons. It has been used extensively by both Democratic and Republican administrations since the Eisenhower administration. The parole process would allow the Department of Homeland Security, DHS, to thoroughly vet each asylum seeker while allowing the individual to apply for work authorization. By granting parole to asylum seekers, we can prioritize their safety and well-being while ensuring they comply with any requirements set forth by DHS. Provisional Waiver. We also respectfully urge the administration to take steps to reduce the significant backlog in the Provisional Waiver program and provide appropriate relief to those stuck in the queue. The Provisional Waiver process allows individuals who are statutorily eligible for an immigrant visa 5 but for their unlawful presence in the country to apply for a waiver of inadmissibility in the United States before they depart for their immigrant visa interview. Until recently, the Provisional Waiver has been a very successful and pro-family unity policy designed to streamline the family-based immigrant visa process for eligible individuals who are part of American families. However, backlogs for the provisional waivers have grown at an alarming rate in recent years. As of April 30, 2023, the wait times for these cases in fiscal year FY 2023 have reached an astounding 43.1 months, or approximately 3.6 years. This is a significant increase compared to the median processing time of 4.5 months just over 4 years ago in FY 2018. The impacts of this backlog have severe consequences for many long-time residents and their families, many of whom are U.S. citizens. Lengthy delays impose uncertainty and unnecessary hardships on applicants and their families, leaving them in a state of limbo for an extended period, and without the ability to fully protect and support their families due to, in part, the lack of employment authorization. We are also concerned that the delays may already be undermining one of the key goals of this policy: to encourage participation in the family-based petition process. Considering the circumstances, we strongly urge you to take immediate steps to address the backlog that go beyond future promises of increased operational capacity. Applicants and their families need meaningful immigration relief now. In the interim, the administration should also consider, on a case-by-case basis, whether paroling in place individuals in the considerable provisional waiver backlog would be warranted for urgent humanitarian reasons or to advance a significant public benefit. Streamlining existing cancellation of removal procedures. Lastly, we encourage the administration to establish a process to make non-lawful permanent resident cancellation of removal more accessible to those who are eligible. Such a process would help to streamline cancellation of removal cases and increase access to lawful permanent resident status for immigrants who are vital contributors to their American families and our communities. Under U.S. laws, non-citizens who have resided in the U.S. for at least a decade, have a qualifying family relationship like an American spouse or child, and meet other stringent requirements may be eligible for cancellation of removal and adjustment of status. Unfortunately, because cancellation of removal applications generally may be filed only once an individual is in removal proceedings, many individuals are not aware of and are unable to apply for this important form of relief. Paradoxically, an individual who is more likely to be granted cancellation of removal and adjustment of status is less likely to access this relief because they will not be a priority for removal. Through rulemaking, the administration can address this issue by instituting a coordinated process that allows individuals to affirmatively request a review of their cases to make preliminary determinations about their eligibility for this relief. Creating such a process would unlock a path to lawful permanent resident status for individuals who meet the rigorous eligibility requirements and improve efficiencies in the processing of cancellation of removal cases in immigration court, the second most common type of case. Unfortunately, positive legislative reforms in immigration are unlikely this Congress due to extreme MAGA Republican opposition. However, The administration can make significant and meaningful reforms through many of the authorities already given to it by Congress. We strongly urge the administration to use these authorities to the fullest extent possible. That's all we have for you in this bulletin. I hope you found this video useful. We will continue to keep a close eye on the developments as immigration-related updates and will publish new videos when there are more updates. The U.S. Immigration Update channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. Thank you for visiting us today, and we'll see you in the next video. If you haven't subscribed to our channel, please subscribe channel for more U.S. immigration update videos.